Hi, and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo. I'd like to welcome you back to our podcast today. And today, I would like to take a few minutes to talk a little bit about the difference between Medicare and Medicaid. Because after all, on the Red Wagon Estate Planning and Elder Law Show, we talk all things estate planning and elder law. A few weeks ago, I had a client come in and was just adamant that they didn't need any type of planning, that they were all set. And I said, well, maybe you are, maybe you're not. Can you tell me in your mind why it is that you feel that you're all set and that you're taken care of? And he said, well, yeah, sure, because I have a will and I have a financial POA in place. And besides, Medicare is going to take care of me if I need long-term care. And kind of looked at him with this puzzled look, and I said, well, why do you believe that? And he said, well, that's what Medicare is. I said, no, Medicare is health insurance, right? Medicare, as it relates to long-term care, only applies in a situation where an individual is admitted to a hospital for 3 consecutive midnights and then leaves the hospital and needs to go to a skilled facility for rehabilitation. Now, notice I said admitted for 3 consecutive midnights. And admitted is a key word there because a lot of times hospitals will take someone in under observation. And it is very difficult, if not impossible, to have that changed. So I just want to highlight that. So first of all, you have to be admitted for 3 consecutive midnights, not under observation, and you have to be there for those 3 consecutive midnights and then go to a skilled facility for rehabilitation. Now, once you get there, Medicare will pay up to 100 nights. Up to 100, okay? So that's significant because it's up to. And what does everybody hear? They hear 100 days, right? That's what everybody hears. 100 days, they'll pay for me. No. It doesn't say that. It says that as long as you are progressing, as long as the rehabilitation is working, as long as you're moving forward, or at least, staying still and kind of moving a little better, they will continue to pay up to 100 days. But inevitably, particularly dealing with somebody with like a dementia diagnosis, they refuse rehabilitation once or twice. Next thing you know, you're getting a call or a notice, typically on a Tuesday, that as of Friday, the loved one is no longer going to be able to receive Medicare benefits. Now, the significance of that cannot be understated because if an individual has a supplemental policy, very often they're not even paying the copays. So there are different tiers, days 0 to 20, and then 20 to 80, 80 to 100. And throughout that process, there's different copays that apply. A person with a supplemental plan may not pay anything or very little as far as the supplement goes or as far as the copays go. So now all of a sudden, you're going from paying very little, if anything, to, as of Friday, you're going to have to pick up the entire bill in the skilled facility, which the Pennsylvania average for a nursing home is $14,000. In our area, in New York and Lancaster, you're probably a little closer to $12,500, but a huge, significant difference. So for people who think that the long-term care costs are being covered, it's just a wake-up call. It's just a reminder that Medicare is only going to pick up a rehabilitation bill in a skilled facility up to 100 days, and that's if you were admitted to the hospital 3 consecutive midnights, and then through the process, you're continuing to rehab. You're doing the rehabilitation. It's working. You're progressing. Things are going well. Well, that doesn't always occur. Even if you don't have dementia, sometimes people hurt, right? They're older. They're achy. They're not feeling well. They don't want to go to rehab. My joke always is you'll get one, but generally the second one is going to knock you off of Medicare. And again, the consequence of that is huge because you're going from paying maybe a copay or nothing to paying an entire bill for $12,500 a month out of pocket. Okay. So what is Medicaid? Medicaid is a federal program that was enacted, and the most common laws that people recognize are OBRA 96 and DRA 05, right? Those are the two laws that kind of set our federal Medicaid in existence and set forth the rules for us to follow. Now, each state gets to interpret the federal rules as they see fit. And, I was very fortunate for about six and a half years. I traveled the country teaching lawyers, estate planning and elder law, trust planning, Medicaid planning. And the reason that I was able to do that is because Medicaid is the federal rules. And under the trust laws, it's called the Uniform Trust Code. So I was pretty much focused on the federal stuff that I could teach so that it was the same across the board. Now, every state does get to interpret the federal Medicaid laws as they see fit. So what we would do is we would say, okay, everybody, this is a blue sheet item. This is something for you to research in your state. There's some nuances to this rule. Some states do it this way. Some states do it that way. So go ahead and talk to your local county office to determine which way they do it in your area. So that's why I was able to teach it federally, because I taught the federal rules and then told everybody to take a look at the state nuances and research those specific areas. So, Medicaid's a great kind of federal program. Now, the state interprets the federal law. So Pennsylvania has what is called a long-term care handbook, which is essentially what the caseworkers use on a regular basis. And it's supposed to kind of be the Bible. It's the Department of Human Services position in regards to each and every area or issue that could arise in Medicaid, which is great, right? It allows caseworkers to know where to go to look, but it also allows attorneys like myself or even consumers potentially to find the long-term care handbook online and then see what the state's position would be. I mean, after all, we're all trying to get people qualified, follow the rules, and do it the right way. So it's extremely helpful to have that handbook in place. The one thing I do want to caution you on is every county kind of interprets the handbook their own way. And then within the county, every caseworker may look at an issue slightly differently. So we practice in several different counties in Pennsylvania. And, after practicing for as long as we have, 20 years, we've gotten very good at knowing what counties tend to do, what their positions are. And then when you practice enough in a specific county, like we have in York, Lancaster, and Adams, you tend to even get the caseworkers to know them and know their nuances. But that's significant because you can literally file the same application, and depending on which caseworker gets it, they may look at an issue differently. So that's just something we like to mention. At Belomo and Associates, we offer weekly workshops. We have workshops in estate planning, crisis planning, special needs planning, probate administration, trust administration. And when we offer these workshops, what we're trying to do is to talk to people specifically in the Medicaid area about what to expect. What can the process feel like? What can you do ahead of time to kind of make it easier for you and your family? What are some easy things that you can get out of the way so that when you're getting into the heart of it and when the stress starts to hit, you have some of the more stressful things out of the way so that we can focus on the heart of the matter. If you would like to attend one of our workshops, please give us a call at 717-845-5390 or check us out on the web at www.belomoassociates.com, and all of the workshops are listed there, particularly for our Medicaid ones. So when we're looking in the Medicaid context, Medicaid is essentially going to pay for the long-term care for an individual in a skilled facility. There is also a program called the Waiver Program or Community Health Choices in Pennsylvania that will pay for care in a person's home if they meet the requirements. Now, there is an income cap limit in Pennsylvania as it relates to the waiver program. So I don't want to get into too much detail or depth on this generic podcast, but let's just say that if a person's income, Social Security, and pension is over $2,800, it becomes almost impossible to qualify somebody for in-home care. Whereas with the nursing home, we don't have that cap limit. We're able to essentially, whatever their income is, we're able to protect or preserve assets. Now, under the laws that I just referenced, DRA 05 and OBRA 96, there are exceptions. There are rules that are very clearly written, black and white, in the law. And that is essentially what we use. We are following the law. We're doing what the intent was. And essentially what we're allowed to do in the state of Pennsylvania, as I sit here today in June of 2022, is if a spouse enters a nursing home, we're able to preserve or to protect 100% of the assets for the spouse living at home. Gee, Jeff, that doesn't sound right. I remember something about the community spouse being allowed to keep a house, a car, and a retirement account, and then half of the assets. Well, wait. We're somewhat correct, right? So the community spouse can keep the house, the car, the community spouse's retirement account. Notice whose retirement account I said? Community spouse, not the IS or the person who's receiving Medicaid benefits. So we can protect their retirement account. Then we're going to take everything else and we're going to put it into the community spouse or the well spouse's name, right? We're going to pile it all in there. And of that pot, the community spouse can keep half, but no more than $137,000, let's call it, right? And no less than $30,000, right? We'll call it just round numbers for today. That number changes, every 6 months, depending on the number we're talking about. So I want to use round numbers so that we're memorizing concepts, not specific numbers, because they do change all the time. So what that means isn't half, right? Because if the community spouse's pot is $500, the most they can keep is $137,500, right? And we'll always bring it down a little. We want to stay under the number, so let's call it $135,000 for just to give ourselves a little wiggle room to make sure we don't get too close to the threshold. That's a huge difference, right? Because if you were thinking half, you're thinking $250, not $135. Well, Jeff, what happens with the money from $135 up to, $835? Well, there's $700,000 there, right? So something has to happen to that money. Well, what it appears to say is that we have to pay the nursing home to spend down that money. But in reality, what the federal rules allow us to do is to take that excess money, not the house, not the car, not the community spouse retirement account, the excess money, turn that into an income stream that's going to pay back to the community spouse in as short of a term as possible. And we're generally creating those terms to be $16,000, $17,000, $18,000 a month. Right now, there is a formula, there is rules behind it, but for the sake of the podcast today, I just want to kind of give a general framework as to how it works. So we're shooting a significant amount of income back to the community spouse as quickly as possible so that we can make that term as short as possible. It needs to be Medicaid compliant under the law, which means there are rules you have to follow, which also means you need to name the state as the beneficiary to the extent that benefits were paid. Well, that is not as big of a deal as it sounds, because we're already ahead of the game. We already kept the house, the car, the retirement account. We already got the half, no more than $135. So every month that goes by that we're getting $16,000, $17,000, $18,000 a month, that's gravy, right? That's money we wouldn't have had. So even if something happens to the community spouse somewhere in that term, we are still way ahead of what we would have been had we not done anything. And there are certain things we may do, like disinheriting the spouse in our estate planning, to make sure that we don't accidentally have assets going in case the well spouse were to pass first. We just want to make sure that the person receiving benefits is protected. Now, the state would have a right to an elective share right, but we could protect half of the elective share right, so we don't necessarily worry about that. because we can protect about half of the elective share right, which leads me to, okay, we know we can protect 100% for the spouse. Wow, Jeff, what can we do for a single individual or someone who is widow or widowed who currently is not married? We can protect at least 50%. Now, the techniques that we use for this are definitely different. We're not using the same turning an asset into an income stream, trying to get it back to the community spouse as quickly as possible. In this context, what we're doing is we're saying, okay, what if we gifted half of the money that the individual owns? So if they own $100,000, let's say we gift $50,000. Now, we all know what happens when you gift $50,000 and you do it in the 5-year look-back period, right? You get your hand slapped. Yeah, of course. You can't gift money in a 5-year look-back period and not expect a penalty. So we're going to take the penalty, and let's say if we're doing, a $50,000 gift, let's just call it a 5-month penalty for round numbers. You say, okay, no problem. I just got penalized for 5 months. I'm going to take the other 50, turn it into an income stream that's going to pay to the person in the nursing home. They're going to turn that money over to the nursing home, and that income plus their income is going to be very close to the amount of the private pay rate, with a little bit of a shortfall, and that shortfall will be covered by the family members who received the gift. Okay, so that's how that works. We often call that a half and half plan, and it's a very viable plan in the state of Pennsylvania, allowing an individual who is not married to be able to protect at least 50% for his or her family. Now, every case is different, right? The cost of every nursing home is different. Everybody's income is different. So the analysis is very specifically dependent. I intentionally did not use certain terms today on this podcast, and it's important to remember that this is for educational and informational purposes only. This podcast does not create an attorney-client relationship with you and is merely for informational purposes. If you would like to have an analysis done of your specific case to the penny, and also we can tell you what it would cost to the penny, please give us a call. We'd be more than happy to assist you with that. The number is 717-845-5390, and we would be able to give you a specific analysis. Today, I just simply wanted to cover the fact that it isn't too late. If somebody is entering a nursing home or a loved one is probably going to need long-term care in the next 6 months, it's not too late. And oftentimes we hear that it is. The facilities will tell us that it is, but it absolutely isn't. Now, I will admit, in a perfect world, sure, we would love to be able to do a pre-plan. We'd love to be able to do an asset protection trust 5 years ahead of time. And then once the assets are in the trust for 5 years, they're protected. Yeah, that would be ideal. But unfortunately, in some cases, that's just not the cards we're dealt. That's just not the way the cookie crumbles, and it's not a possibility. So in those cases, what we need to do is to figure out what we can do in crisis. And the crisis rules are what I just described to you today in this podcast. We, as I said, offer weekly workshops, and we have links to the workshops, particularly the Medicaid crisis workshops, because we understand that it may be difficult to get in if you're caring for a loved one and you're not able to get away. So we do make them available via a link that you can watch. There's two concepts that I want to cover quickly here that I think are very often misunderstood in the Medicaid context, and frankly, just flat out people get wrong. It's the filial responsibility law as well as Medicaid estate recovery. They are different. They don't stand for the same proposition. The filial responsibility law in the state of Pennsylvania was basically born in a case called Pittas, Pittas. It was a case that came out from memory, let's call it 2015. I may be off a year or two on that one. But essentially, it stood for the proposition and stands for the proposition that children, spouses, and parents can be responsible for the nursing home debt of the child, spouse, or parent. The case itself was a case in regards to a child who was the power of attorney. He borrowed or stole, I guess it depends on your perspective, $93,000. My understanding is he up and left and went back to Greece. Well, lo and behold, mom enters a local nursing home chain in our area, and she goes to apply for Medicaid, and she's denied. Why is she denied? Well, because she gave a gift to her son of $93,000. So through the process, essentially, I think what happened, in my personal opinion, is that the judge realized there really was no way to hold the son liable. The power of attorney allowed for gifting provisions. He went back to Greece, but the judge was angry. The judge was going to figure out a way to hold him responsible. And in the law, we always say bad facts make bad law. This is a case that I think was a bad fact case. That judge was going to prove that that son did something wrong and that he should be held responsible. So he figured out a way under this filial responsibility statute that is a support statute that was on the books in Pennsylvania, and I believe it's on books in 32 to 35 other states in the country. And now that it came to fruition in Pennsylvania, you're seeing it now in other states because we kind of took the lead on it. I don't think that case ever would have come down that way had it not been such a bad fact case. But that isn't something that worries me. And the reason for that is because if you go see your elder law attorney, if someone's going to enter a nursing home, they can help you. They can protect you. The only way a nursing home can come after somebody for a bill is if the nursing home is owed a bill. If the family gets the individual qualified for Medicaid, there is no bill. So that law does not worry me because we take care of our families. We get them qualified. What you want to watch is just spending down the money. That's the last thing you want to do because there's still a 5-year look-back period. You want to get ahead of it. You want to call your elder law attorney as soon as possible. What estate recovery is once you've already been receiving benefits, when you die, the state is allowed to go after the probate assets of an individual to cover the amount of care that was provided. Now, the significance of that is, remember, in order to qualify for Medicaid, you have to be under $2,400 or under $8,000 in assets, depending on your income stream. So in order to qualify, we know you're already under $24,000 or $8,000. State recovery is going to try to recover anything that's over $2,400. So we just simply want to make sure that the assets are under $2,400 and or they don't go through probate, meaning they're beneficiary designated to a family. This is why you want to use a professional. This is why you want to go to somebody who specializes in this area. Estate recovery is the last thing I worry about because I know when we do a plan correctly, we're not going to have to worry about it. So earlier when I mentioned the different types of planning for married and single individuals, notice I didn't tell you that at death they were going to take any of that money. If you do it properly, they don't. So estate recovery is just when they die to get paid back up to the amount of care that was provided, and the state only goes after the probate assets, which is why we make sure that the individual is below $2,400 and or everything is beneficiary designated, jointly designated, so that it doesn't go through probate. Estate recovery is not as big of a deal as what it sounds, simply if you use a professional and they know what they're doing. Well, we hope you enjoyed the Red Wagon Estate Planning and Elder Law show for today. We talked a little bit about Medicare versus Medicaid and filial responsibility versus estate recovery. Please join us on our next podcast where we'll talk another topic, everything about estate planning and elder law. Thank you very much. We'll see you real soon.